Patent demand letters reform is an important part of curbing abusive practices that hurt legitimate businesses, as you know. However, I'm concerned that overly broad definitions of patent assertion entities and other provisions that have been proposed, such as fee shifting and joinder, will limit our nation's research universities and their ability to have patented research discoveries transferred to startup receiving venture funding that can develop and commercialize these early discoveries. The University of South Florida, just outside of my district in Tampa, Florida, is a world leader in university-based patents, licenses, and startup companies, and is a major regional economic hub and job creator in our area. Ms. Rainier and Professor Gagliosa, excuse me if I mispronounce, what do you believe is the appropriate balance to ensure that the technology transfer process thrives while simultaneously implementing real reform targeted at bad actors with no intention to commercialize innovations?
Thanks. I think a lot can be done by sort of looking at, so I've talked about the history, a long history of courts prohibiting bad faith assertions of patent infringement. And a lot can be looked at by looking at some of the examples the courts have condemned in the past. They look extraordinarily similar to what we see these bottom-feeding patent trolls doing today, sending out massive amounts of demand letters, targeting the customers of the firms that actually manufacture the allegedly infringing technology, making claims that they couldn't, claims they could not have possibly investigated the merits of. So, I think if you look back at those types of cases, you actually can see there's a very clear line between, what is really so abusive as to be considered in bad faith, and the efforts of, say, an operating entity or legitimate efforts by a company to try to license their patents or resolve a dispute before it goes to court. Those lines have been drawn by courts for over 100 years, and I think they're lines that courts can continue to draw.
Thank you.
I would agree with Professor Galuzia, and I understand your question to be, how do we allow for legitimate letters and still legislate against the bad faith letters? And I think what's important to know is that those who are sending legitimate letters, they include the patent numbers in their letters where possible. They will include why they believe someone is infringing, and they will include information so as to allow the parties to really understand the scope of the claims and why there's a claim of infringement or why the patent is not invalid. This is the activity that bad faith patent demand letters don't include. And so I would agree with Professor Galuzia that there is a long line of cases that see this distinction and make the distinction, and I don't think legitimate patent holders should be concerned about any legislation against bad faith letters.
Thank you. Anyone else on the panel like to respond to that question? Okay, thank you. I'll move on, if that's okay. Ms. Rainier and Professor Gagliosa, what factors do you believe should be prioritized when determining standards for demand letters that would address the abusive patent troll practices while still preserving the legitimate patent holders' ability to negotiate license agreements with potential infringers?
Just very briefly, a couple of factors that I think we've talked about so far. One is the number of letters that have been sent out, right? If a patent holder is sending one letter to one specific company, well, it seems fairly likely that that letter is based on some sort of investigation that gives the patent holder a good faith belief that that recipient is infringing. When you send out, as MPHJ did, 16,000 letters to users of common office scanners, it's extremely unlikely that MPHJ has actually investigated the allegedly infringing conduct. So the number of the letters can be a nice source of indication of whether the investigation has happened, and also the specificity with which the letters both describe the patent claims and also the allegedly infringing technology.
Thank you.
I hesitate to give a complete list of factors, and the reason is this. Oftentimes, what we see as when letters are shown to us is that it's not one statement in isolation that's a problem. It's the totality of the letter that makes clear that the patent holder has not done an investigation, is trying to extract money. For example, references to the extreme cost of litigation, and I've seen letters with actual links to tables showing the recipient how much money they can receive. Litigation does cost a lot of money, that's true, but it's the fact that they put these statements in there along with other vaguely threatening language that together makes us recognize a bad faith letter. So I hesitate to say these certain things make a bad faith letter. It's oftentimes when we see it all together that we can tell that this is not being sent for legitimate purposes.
Thank you very much. I yield back, Mr. Chairman. Appreciate it.